everybody. Welcome to this session in which we're going to explore a bit of what is polycentric law, what's understood about it, and then we're going to build on top of that in that next couple of days. And yeah, I chose this background. This is like Casbaggy on northern Georgia, absolutely beautiful. If you guys are going to be here for a few more weeks, still I do definitely recommend it. It's like 5 hours away, but relatively easy to get to. Just a bit of my background. I'm Christian, managing partner at Ixion, our law and legal engineering firm, and I also serve as a fractional general counsel for Vitalia and a Luz fellow at the Foundation for Economic Freedom in Honduras. My background has been mainly in corporate and commercial law, banking and financial law, and economics and dispute resolution. And I also have a background as a public policy consultant. And these are some of the academic institutions I've collaborated with in the past. Fraser Institute, the Friedrich Naumann Foundation from Germany, and the Neotera, which is part of the Atlas Network. And this has brought me to have a particular experience with both Web3 and crypto developments, but also polycentric law, special economic zones, and so on. Polycentric law regards the legal services that governments provide, defining rules, policing, enforcing the application of rules and settling disputes as a ripe field for competition. What if there could be more direct competition between governments or legal providers for these areas? When a government claims a monopoly in the law, it tends to neglect its subjects' needs. That's just human nature, right? They don't have competition, they don't have the incentive to innovate and to have better services. In a polycentric system, however, providers of legal services care more about what consumers want. Consumers are, in this scenario, the users, the citizens, right? The members of a country, of a municipality under which they live. So polycentric law is a theoretical legal structure that recognizes competition within legal systems and which may compete or overlap in a given jurisdiction as opposed to monopolistic statutory law, according to which there is a sole system or provider of law for each jurisdiction. So we're going to see how legal systems already compete. That's just a natural phenomenon. And you can also see this amplified in situations where it devolves into conflict that bring to war, right? Many times wars happen because of different interpretations or different ways that they want to apply law and international treaties and so on. So that dynamic of competition between legal systems, between jurisdictions is already very much present. What if we could replicate those dynamics within only one space, within one territory? The term polycentric was originally coined by Michael Polanyi. He's a avid polymath in the mid-20th century. And he used the term to describe complex systems with multiple centers of decision-making authority. While he applied it primarily to economics and science, his ideas influenced later thinkers in the field of law. So this idea of polycentric authority was echoed by several intellectuals, academics, including Nobel laureates like Friedrich Hayek or Elinor Ostrom, who worked in decentralized, what they call decentralized law, right? How could you have these different applications that again compete with each other, but what if we could apply them in one territory? We could have different legal systems competing and complementing each other. Most recently, Professor Tom Bell from MIT, which is someone who has very much influenced my work, is probably the current champion for the whole polycentric law theory and how it's being applied. He defines polycentric law as a legal system in which multiple sources of law coexist and compete within the same jurisdiction. This concept stands in contrast to what he calls monocentric law, where a single and centralized authority dictates legal rules and enforces them. Tom Bell's advocacy for polycentric law emphasizes the benefits of a decentralized competitive system over a centralized monopolistic one. He argues that such a system can provide more efficient, just, and flexible legal solutions tailored to the diverse needs of society. So this is very much niche academics, but you can find that these are some resources, some references that you can explore if you are so inclined. Of course, Professor Dell's book, Your Next Government, From the Nation State to Stateless Nations. And then there's this book with several essays that was edited by David Betancourt, Peter Gordon, and Alex Tabarrok, called The Voluntary City, Choice, Community, and Civil Society. There are some works in that related to polycentric law, and then you have just scattered works and academic articles about it. The Special Jurisdictions Journal has several stuff related to it, and this is one by Alan Mendenhall, which I find particularly amusing, because this is from the perspective of our seasteaders friends, right? The people that want to develop a community at sea. So is My Country Lies Over the Ocean, Seasteading and Polycentric Law. This is a paper about it. So there are resources that you can tap into if you're so inclined. The key characteristics of what would be a polycentric law system related to how Campbell defines it are, well, you can have multiple legal providers. So if we take right now the Ambassadori Carreti, the resort that we're in, and we would have each of us as residents, right, as citizens of ZuVillage, we could choose the legal system that applies to us, the regulations that apply to each of us as an individuals, or to the companies that we're running, we're building. There could be multiple legal providers. These are providers of both the law itself that you want to have applied to yourself, and the enforcement of it, in theory at least. You could have different police forces or different courts for it. Then, of course, a key feature, it's all voluntary associations, right? You can pick and choose what type of system and what type of governance provider looks over you, right? And this is this already exists in real world, right? The sense that it's all voluntary, in the sense that you can vote. You can vote with actually on the elections, but you can also vote with your wallet, and you can vote with your feet, right? If down the line you don't like where you're living, the type of governance services that you're receiving, or the laws that apply to you, you can make a decision to migrate, right? To change that legal provider. Of course, that's a very big transactional cost. You are changing your life, you're moving to another place. But you can also do that as of now. Competition and innovation. As legal providers, we need to compete amongst each other to be able to attract users, to be able to attract residents. That enables the innovation phenomenon to actually happen. All right, what if we add this new service to our residents, or what if we lower a bit the fees for it? You get that competition phenomenon. And arguably, this is sort of the stuff that we're already seeing now in the whole Susalu ecosystem, right? We have these different pop-up cities, some linked to real-world free jurisdictions, and they're all competing to keep you, right, to attract us to them, and hopefully long-term. Decentralization, of course, is there's several providers. There is no centralized authority, and if you are with one provider and you don't like it, well, you should be able to change it, right, voluntarily. And this, of course, all of this enables customary and spontaneous order. It enables customs to evolve, customs in the way that we practice business, in the way that we interact with each other, to evolve more naturally, to generate new ways to do things, and to have them become norm eventually down the line. Like what we're doing with the raffle, right? The raffle is an ingenious way to fund some things, right? By the way, I think we're going to try another raffle so we can fund the vehicle for the community. So just so you know, in the next few days we should have news about it. But it's precisely that. What if we can develop new customs, right? What if we enable that spontaneous order to develop, and whatever works, whatever sticks, we can then formally recognize it and potentially include it as law, as norms. The way we are, or the way the Tom Bell is defining polycentric law is a competition of legal systems within one territory. But of course, there are historic instances when we see accelerated competition within different jurisdictions. This is a map of the Hanseatic League. The Hanseatic League was essentially this association of free jurisdictions. Some were city-states, some were duchies from the Holy Roman Empire, free cities from the Holy Roman Empire. I believe Hamburg was a free city, a free imperial city. And they were independent among each other, but they had agreements among themselves, commercial defense agreements to collaborate together, and this enabled an accelerated innovation process, accelerated commerce, and with it also accelerated growth and wealth creation. So this is particularly, for me at least, a particularly interesting point of time of what was the Hanseatic League. Of course, this came to an end with the Pact of Westphalia, the first Napoleon afterwards, and the end of the Holy Roman Empire itself, where Germany became something more centralized, more unitarian, and we lost some of those dynamics. Another example is the Silk Road, right? The Silk Road was an association of very small jurisdictions throughout time that had these agreements for commercial and defense support through hundreds of years, right? And it started in China, it ended in Cairo. I believe it was, I heard Alexander Bard the other day said that of course the new Silk Road won't work because the old Silk Road, like the Belt and Roads Initiative, won't work because the old Silk Road was not a highway to go give praise to Beijing. No, it was a free association of jurisdictions that ran through all Central Asia and the Middle East and everything, right? And then you have this is a magnificent case study by itself, right? Even you have cities, what is now Kandahar in Afghanistan, that was an Alexandria, right? Was a very important city of the Silk Road, which is now, of course, a city that's very much cut off from the rest of the world. But it was because of those institutions, it was because of those dynamics that were enabled to flourish, right? That competition, that innovation, that cooperation. Of course, another example of this were the so-called city-states, the jurisdictions of the Italian peninsula. You got Genoa, Venetia, all competing with each other, and of course, these dynamics enabled the Renaissance itself as well. And if you look for a map of just like wealth creation in the world, which of course speeds up after the Industrial Revolution, but you do see like little bumps in history, and one of those bumps in wealth creation was the Italian city-states and the competition that they had with each other. In more recent times, we still nowadays can see this dynamic in the US. Of course, the level of autonomy that the states in the United States of America hold has come in decline, after its founding, right, in 1776. The federal government has gotten bigger and ever more powerful. But there are still competition dynamics between states. But you can see nowadays, right, how many people that were living in California migrated to Texas, or to Wyoming, right? Or who was it, like, it's not Kim Kardashian, but some people that, just ditched California and bought themselves some very nice real estate in like rural Wyoming, right? So we can still see those dynamics nowadays about relatively small jurisdictions competing with each other. But what if we make the leap? What if we go to the next step, which is actually what we were talking about, polycentric law, having different legal systems competing within one zone. And this is what brings us to just the Honduran case study of the special economic zones, about which we're going to discuss a little bit more in detail tomorrow at 11 and the following days. what happened in Honduras is something related to this quote that stuck with me that I read back in like law school, in this book, The Political Ideal of the Rule of Law by Friedrich Hayek. This is a compendium of seminars that he gave, I think it was in a university in Argentina or something. And at some point he gets asked, somebody asks him, like, do you think, which do you think is better, right? Like common law, which is the type of customary law that you find in the US, in the United Kingdom, in Australia, which is based on custom, which is based on practices. Do you think that's better, or is it better just civil or continental law, which are these codes that we find in continental Europe? And he goes reflecting and he says, well, I think that common law enables a bit more flexibility and is more friendly towards innovation, but it is also prone to leave blank spaces, legal lagoons that are unaddressed. And I think that continental law is a bit better in having a general coverage of situations, but it also leaves more space to discretion from judges, right? Judges can have discretionary powers when interpreting law. So he concludes, I think the best scenario is having a country, I think he mentions a small country with continental law that allows for pockets of jurisdictions with common law being applied. So that was one of the underlying ideas behind the special economic zones that have been developed in Honduras. You have Honduras as this continental law country with the common challenges found in Latin America with rule of law, legal stability, and everything. What if you allow, we have 3 zones, what if you allow zones that have a high level of autonomy that can generate their own regulations and their own laws for almost every matter, and allow them to inspire those laws and those regulations, to have those regulations inspired by common law. So as of now, we have 3 special jurisdictions in Honduras with this. One is Prospera, the other one is Ciudad Morazan City, and the third one is called the Orchid. We're going to talk a bit more about them tomorrow, but for our purposes, I want to share how it works in Prospera and how Prospera is actually enacting polycentric law as we speak. So these are what Prospera calls regulated industries, right? These are industries that, given their nature, given the consequences that a bad application of them can have on the population, they are especially regulated, right? As you can find elsewhere, right? Finances, medical services, these are all regulated industries wherever you go. So construction, to a certain level, energy and mining, food and agriculture when it becomes industrial, health services, manufacturing, private security, waste management, and finance and insurance. They all in Prospera need to make what's called a regulatory election. A regulatory election means that they need to pick, the company needs to pick the regulation that applies to them. And for doing so, they essentially have 3 options. There's 3 ways that they can do this. One is they can select the existing legal framework from over 30 OCDE, what they call best practice peer countries, and they can have it applied to them, to what they're doing. So say you want to start your medical practice there, or you want to start a fintech. How do you want it to be regulated? Okay, you say I want to apply New York state law to my financial company right here in Prospera, or I want to apply, maybe I'm more familiar with the Frankfurt stock market. I want to apply German law, or I want to apply Japanese law to it. You can do it. There may be additional costs because experts would need to be hired, but it is a possibility, and it is parting from the common understanding that these are developed countries and this would be good regulations to apply. So that's one option. The second option is what's called the optimal regulations. Optimal regulations are regulations that have been developed, or you can develop your own, right? And then you present them to the Prospera Council that needs to approve it. The Prospera Council is the closest thing to the legislative body in Prospera. Of course, they need to comply with the international treaties that Honduras is part of. They need to be in accordance with international best practices, but you can develop from scratch optimal regulations. And once they're approved, other companies that come afterwards can pick the one that you already got approved, right? We're going to see a bit of that in practice. And the third option that Prospera offers is no specialized election, which means that you just start operating under general common law provisions. I mean, you start operating under, the commercial code in Prospera. So this allows people to, hit the ground running, to start very fast with their projects. However, you do lose corporate veil. So, like if something goes wrong, you, the founder, would be personally liable for wrongdoing of the company. And any damages that may arise from your wrongdoing is multiplied by 3. So it's a big risk, but it's at least an option that some of these companies have. What I've seen is precisely that some companies start operating without a regulatory election. They put themselves at risk for a couple months until they haven't figured it out, and then they select either an optimal regulation or a best practice peer country framework. So those are the 3 options. And okay, so how have those options been used so far? So currently we have 4 optimal regulations that have been approved in Prospera, 2 for the financial sector and 2 for the medical sector. One is the financial regulation A, which I was the lead designer of. That was designed for financial institutions and banks. So it includes, the type of provisions that you would expect in a banking law, right? What are the requisites? What are the requirements for a bank? How does the approval work? The profiles of the board of the bank and so on. Of course, anti-money laundering provisions. And how we did it for the financial regulation A was that we essentially applied the provisions from the Bank Secrecy Act from the US, which is like the law in the US for anti-money laundering for financial institutions, which is, as you can imagine, is rather rigid. It's rather tough to comply with it. It has a lot of requirements. It's actually even more rigorous than the one that you find in Latin America. But that's what made sense for a particular project at the time. So that was the second part. The third part of that law is risk weighting of assets and liquidity requirements. How are we going to deal with that? And we were able, I think that was definitely the part where we were a bit more innovative, because there we implemented a model that was originally designed by Mervyn King. Tom was commenting on the first week, commented about Mervyn King's book. Mervyn King was a governor from the Bank of England, essentially, the president, the chair of the central bank from the United Kingdom, and he developed some ideas about how best to deal with what he calls radical uncertainty after the 2008 crisis. I don't want to get too technical about bank liquidity, but yeah, it allowed us to be innovative and still be able to fall back to good practices if needed. And then the fourth part of that law is just liquidation procedures in case they're needed. So that can be used by any bank, by any financial institution that wants to start operating in Prospera, as it is. So if you want to start back in Prospera, you can select that law, or you can select, again, the existing legal framework from over 30 countries, or you can develop a new one, right? Or you can mix and match. So that, right there, we can see a competition between regulations happening. The second one for the financial market is the FinTech Regulation A. The FinTech Regulation A was developed by Deloitte, by the consulting firm. Deloitte prepared this not so much for banks, but more for like general FinTech companies, payment services, gateway providers, crowdfunding companies, that type of things. And again, just applying good practices, but making it also common sense. So that regulation is also available as of now. Like we have some clients that are working with the FinTech Regulation A. There's some clients from Slavic Europe that decided to, because that's what they knew, and that's an interesting phenomenon that we're seeing as well. That, for example, there's a client that has an exchange in like Slavic Europe, and they're doing it now as well from Prospera, but they're applying the law that they were already applying to their operations in Prospera. Like, it may not be the most efficient law, right? It not maybe the most cost effective, but because it was just the one they knew, then it made sense to them to start applying that one. So I thought that was an interesting phenomenon. But okay, so these are the two optimal regulations that currently exist for financial activities, but they're like one is more for banking, the other one is more for fintech. With the medical industry, there we are seeing a more direct competition. So we have the Health Services Regulation A and the Medical Innovation Regulation. The Health Services Regulation A was developed by the GARM Clinic. The GARM Clinic is an institution that has over 20 years operating. It's led by senior American MDs. Dr. Glenn Terry was also like heading the Olympic Commission for Medics in the US. So very serious people, very well established, and they developed the Health Services Regulation A. The Health Services Regulation A, if you pick it as a medical provider, so once you pick the Health Services Regulation A, once in, you then need to pick another. You need to make another election for each treatment. So it is already taxative for some treatments, like cancer treatments, cell therapies, PTSD stuff, but for each one, you need to perform another election. So to me, like just the Health Services Regulation A is probably the highest expression of polycentric law nowadays. However, it is very blocky, like in the sense that like it can be not convenient to be making these elections for each treatment, right? And it's also very much US based. Each treatment needs to, like some of them, for some types of treatments, you do need to make an election based on a US jurisdiction, a state from the United States, or apply an approved protocol, a medical protocol. I don't want to get too technical, but essentially, guidelines, medical procedures that have been approved by an overseer. That's the way it works with the Health Services Regulation A. So say you want to start a new cancer treatment and cell therapy, you can do it. You select the Health Services Regulation A. Once you're in the Health Services Regulation A, then you need to make another decision for each of the treatments that you're doing, very much based in US regulations and taking into account protocols, medical guidelines that have been approved by regulators. The second one is the Medical Innovation Regulation. The Medical Innovation Regulation was proposed by Minicircle. Minicircle is this company that's doing follistatin therapy and some medical trials down in Prospera. And in this one, actually, Professor Tom Bell, I know, collaborated with it, but this one takes a completely different approach. Like this one takes a first principles approach, right? So if the Health Services Regulation A asks you to perform an election for each treatment, and it's very prescriptive in the way that you need to be regulated, the Medical Innovation Regulation is completely the opposite side. It takes a first principles approach and just asks you to have three elements. One, you do need to be insured properly, detailedly insured. So there is insurance for the treatments that you're performing. Two, there needs to be a very in-depth informed consent by the patients or the clients, right? Proper informed consent and signing of waivers. The client does need to sign a waiver that exempts you of responsibility if something goes wrong. There is, of course, a risk to it, but this is also designed, this one is designed for innovative therapies, innovative treatments that, respect your right to try. Your right to try, like if you have a chronic disease or you're in a terminal stage, God forbid, for a particular disease, you should have the right to try experimental treatments. So these actually are competing with each other. So there's the industry, the medical industry is probably the one that's growing the most in Prospera, and now we have people that are starting new treatments, that want to start new trials, and they come, they look, all right, these are the two options. They say, well, I really don't want to, spend 3 months and spend thousands of dollars in attorney fees for developing a new one. Maybe I just select one of the existing ones. What are my options? Okay, no, I want this one, or it makes more sense to me to select this other. And actually, we're currently working on a fork of the medical innovation regulation, because that's also that would be allowed, right? Say you take one of the existing optimal regulations, but for whatever reason for your business, it's great, it makes sense, but it would be even better with some slight changes to it, right? So that is a possibility. But yeah, that's what we're seeing in practice. Bear in mind, Prospera just started building in 2020 at the height of the pandemic. So it's still very much early stages, but we're already seeing some of this polycentric law phenomena. What I find also particularly interesting that we're going to see in time is the anthropological effects of this, like from a legal anthropology standpoint. How is the legal culture going to continue to develop? How is the interpretation and enforcements of these regulations going to happen? And what will be the story when existing legal frameworks from other countries are then applied in Prospera, right? Because, say you select a law from Japan, right? And then you hire some experts in Japanese law to make sure that it's being well applied. But what if their interpretation in a particular part of that law is different from the interpretation that the regulators in Japan may have? It's the same law, but it can be applied slightly different. So we can see a fork in enforcement, a fork in application, and the implications for legal anthropology that may have. So that was about it. Stuff that I wanted to share with you. So thank you, and if you have any questions or comments, then this is where you can reach me. I do recommend Casablanca.
Can we ask questions? Is that right? Or
Yeah, if you have any questions or comments, we still have like a 10-minute or thing. Yeah.
I mean, I have one. Is what I've been saying to people is this is really good as a so for rolling out code. The idea of rolling out a long-term standard or whatever LTS for your entire customer base as the very first rollout is absurd. No one does that. Yet, if we look at law, how law is done, it takes many years, and then say in DC, federal law, and then it's there, and then like DMCA, we stuck with it for 30 years or so before there's any updates, and it's a grand experiment among many people. So do you think that this polycentric jurisdiction offers a way to more reflect the pattern that coders do, where basically you've got A/B testing, and you've got small groups? I'm kind of riffing off your comment about forking, but yeah, basically that we can with a sandbox environment, not commit everyone to the experiment, but actually be much more empirical in our thinking and rollouts. Do you think that is doable? Or?
Yeah, for sure. I mean, like speaking about the Prospera case specifically, that's just a big sandbox, right? Like some people are using it as a headquarters for their companies, but some other people are just using it as a sandbox to launch an MVP, see how it works, how could they improve it before going to a bigger market. And just from a legal engineering standpoint, just from a Web3 standpoint, it also allows you to make this, these experimentations on a controlled environment, and where you also have like the legal clarity that you're not going to get in trouble for it, right? So well, yeah, we have been working in like some innovations in that sense, because as we discussed earlier as well, like this is still a frontier. Like how are we going to understand DAOs, for example, or continuing blockchain-based social interactions. Yes.
So is this mostly for regulations of like self-regulation frameworks, or how do you see in practice, like how can a person be aware, like as a user of a service be aware of the law? Like it would be a little bit eccentric if I go to Prospera and I sign up to this service, maybe from abroad, and they decided, Georgian law applies for this company. Then, as a user, I would need to be aware of what is the Georgian law. So I think it would be, if not confusing, at least unfair, because law really makes sense when you're aware of it, and you should be aware of what is the law and what kind of services and terms the company is offering you.
You really need to read the terms and conditions.
Yeah, but if it's written in Georgian, I couldn't even make out the characters.
No, it's and that's definitely a great point. Companies from regulated industries, they do need to make it very clear to the users what is the regulatory election and make it available for them. And there is, a public registry of Prospera companies and what is the regulatory election, so you could check that. Of course, there is a transaction cost. I mean, sometimes you just want to use Uniswap right now and go, right? But at least, it's made available, and even if it's Georgian law, they would need to have it translated both to English and Spanish, so it should be available. Some people don't like this aspect of things, like the OCDE and the Financial Action Task Force definitely doesn't like this because it can make it confusing, definitely, for users, which law is applying to me, which law applies to this company. In the same way that they don't like to buy, many people don't like to buy because of that, because you got the emirate of Dubai itself, but within the emirate you have over 30 special economic zones, and you're walking in Dubai and 4 squares of the city are from one special economic zone, and the 4 other squares are from another one, and you don't even realize it, right? So definitely there is an argument about it, about that it can get confusing or that it can be unclear. So the challenge is to make sure that it's as clear as possible for users, because it's not the intention to vulnerate them, but just for them to have the option. And again, worth remembering, these optimal regulations need to be up to international good standards and do need to comply with international treaties that Honduras is part of, which are just general baseline good practices for consumer protection.
So what about criminal law? Is it also polymorphic in Honduras, or do citizens of Prospera choose which criminal law to conform to, or
Not criminal law. So we're going to talk about a bit about that tomorrow. How it works is the only regulations from the ordinary Honduras that do apply to Prospera and the special economic zones are those related to migration. Migration matters still depend from the central government, and criminal matters. You still apply the criminal law from Honduras. Yeah. And of course, there's international treaties against money laundering, terrorism, and all those types of things. So there's also a baseline.
And there's the Rotan Commercial Code. Maybe that's a good time to mention the kernel concept as.
Yes. So this opportunity for you to select an optimal regulation refers to specialized regulations per industry, like we saw for financial, for medical, but there are some common regulations for all Prospera companies. That includes the tax rules, labor norms, and also what's the equivalent to the commercial code, which is called the Rotan Common Law Code, which is based on ULEX. Maybe for those of you that are not familiar, ULEX is this open source commercial code that has been developed by Tom Bell, again, which is based itself on the Uniform Commercial Codes of the US. As you may know, in the US, regulations are based on case study, right? On awards on rulings in the past, by previous judges. So, you know, you go to court in the US and you need to cite to reference the case in which that law was generated, right? As you see on the movies, right? Johnson versus USA, whatever. But of course, that's not very practical. So there are associations that have codified it, essentially. So you can read it as code, as you read continental law. And that itself has been adopted by many American states for their own commercial codes. So what Tom Bell did was he took this uniform commercial codes based on case study and fragmented it and made it very approachable and very available in an open source way. It's a great tool. It's not the friendliest of tools because it does reference a lot of federal stuff from the US. But what Prospera did was they took ULEX and they adapted it to their needs. They include some elements from, you know, continental civil law, and that's what became the RUT and Common Law Code. And what Kyle has been working on is how can you create a kernel, essentially, based on ULEX that could apply for Web3 organizations. Maybe a society community, we don't know, right? But that's the idea of the kernel. You develop kernel based on ULEX.
So how accessible is, creating a new regulation for, let's say, startups? For example, a lot of PGF, like lotteries, are in most countries like monopolized by the state and thus made like forbidden or like ultra regulated. So how accessible would it be for us to go there and like figure out like a different legal structure that would benefit us or like make it more accessible?
Yeah. I don't think that the financial optimal regulations that we just mentioned would cover lottery. We would be able to study it. But all right, the option for a lottery company would be, okay, again, you need to make a regulatory election. It is a regulated industry, there are risks of money laundering and so on. So you do need to make a regulatory election. You could select the existing legal framework from another country that you may want to apply, or you can develop your own. You want to develop a new regulation. There's a lot of variables, right? What's the complexity of it? What's the risks of it? But, just shooting from the hip, I'd say it could be less than $10,000, just the whole procedure, and then maybe 3 months from when you filed the request. You need to go to public hearings with the Prospera Council. You need to defend the optimal regulation that you're proposing. But if everything's all right, if everything's well done, I'll say under 10K and 3 months. Yeah.
Cool.
Yeah.
Nice.
Yes, of course.
Okay, so just trying to get how it works. You registered a company in Prospera. You chose Switzerland law, whatever, like Swiss law, for example.
Yeah, if it's for a regulated industry.
Yes, like financial services.
Yeah.
Yes. And then you made some bad stuff according to the jurisdiction. Who will go out?
You make some what?
Like you made a fraud. Well, fraud is a critical example, whatever. But you like made something wrong. Who will go out?
Well, there would be a regulator, the financial regulator. That's in Prospera. That's a great body that's made up of, you have Chirag Shah, which was one of the founders of the Dubai Financial International system. Sohan Gupta, which has worked with enforcement agencies in the US. So there's a pretty great regulatory body for financial activities in Prospera that gives.
For foreign activities, like, okay, you, like, first thing, where the court will be, and the second, like, if you are guilty, like, who will go to the international search, international, who will accuse you and who will, send this, laws to find you?
Long answer short, in the case of a fraud, you have criminal implications, civil implications, and administrative implications. Administrative is with your regulator. You may get fined, you may get closed, the company. Civil implications is, the company may need to pay its customers, right? It goes through a liquidation process. It needs to pay what it owes. If it has an insurance, then the insurance kicks in as well. And for criminal matters, generally speaking, and what would happen in Prospera, because you do need to apply criminal law from Honduras, is the legal representative of the company or the board of the company, if it happened in a systematic way. Of course, if there are international victims, there may be some dynamics of other countries, of prosecutors from other countries that may want to go after the responsible people as well. Yeah.
Okay, so am I right that you have special processes for closing the company and figuring out financial
The-
charges? Let's say.
Yeah.
And then you have criminal system of Honduras that if you are proven guilty will go and find you internationally. So they will be the search body.
Correct. They would be like the prosecutor that has immediate jurisdiction over you. But again, in the case of a fraud that may be international, other prosecutors from other countries may get interested if there are victims from other countries. And yeah, also like Prospera, even if you need to apply the criminal code, they can have their own police force. So there is an idea about building a bamboo prison. But yeah, down the line. It's part of governance, right? Yeah.
What do you see as the downsides, if any, of the Prospera project as a whole?
As a whole, I still need to pay taxes.
So there's no downside?
Well, at present there is still some political friction with the central government. We still don't have a port, which may be something that manufacturing companies may be interested in. It is, again, of course, it is a novel jurisdiction. Depending on the type of investment, you may be interested in something that's more established, like the British Virgin Islands or something.
I don't mean drawbacks as features as yet to be released, but rather drawbacks of the philosophy, maybe, of having drawbacks of the philosophy. What could the consequences be, or what could possible high-level drawbacks be to this approach?
That transaction costs may be high because of the complexity of it all. So it can be harder to understand than more straightforward jurisdictions, like an attorney is advised. So there is a complexity and there is a cost for understanding how it all works. But generally speaking, I do say that it has internal dynamics that I enjoy very much and that I feel very safe with. Like, for example, with dysregulated industries, yes, you have the public law regulator, but you also have the insurance company. All companies need to be insured in Prospera, and the insurance company has the incentive of making sure that you are complying with law, so they're not liable. Yes.
Just to make the question more effective, because the question in itself is totally legit, I think. What do you want to compare it with? Do you want to compare it with mainland Honduras, or do you want to compare it with Switzerland, or with, let's say, the European Union, or let's not talk about dictatorial states now, but it's always the question, then he can very much better answer these and these aspects are more effective here, or these use cases and these use cases might be more effective in Prospera.
I'm not. So my experience is obviously just basic in the sense that my company is registered in the Netherlands and I comply with Dutch law. So that would be an interesting point of comparison. As a company, maybe one of the drawbacks. But I think that what I'm trying to get at is whether or not there are drawbacks for the state of the legal system as a global entity as a whole. Because right now you have different states and they are in competition with one another, trying to attract companies, etc., to come be here because we have flexible law, for example. So I do see how this can be a better environment because you have that regulatory framework and it's built for that competition. So you're that seems good. But are there any drawbacks of that kind of competition on for that global kind of law ecosystem?
Thinking globally, since it's still novel, since it's still a novel jurisdiction, depending on who you're dealing with, there may be still a step of you explaining it to them. Like if you're opening a bank account in an international bank, you may need to explain what the jurisdiction is, how it works, and so on. And one aspect of it that we still haven't quite seen work is once we get conflicts, there's an arbitration center, there's a private justice center for it. Once we get conflicts and once we have a trial and a process and an award, once we get the ruling, how exactly are we going to enforce that ruling if it may have effects outside of Prospera? So are we going to have to deal with the courts of ordinary Honduras, which can take a while? So that can be a drawback for sure. But that also depends on the type of industry that you have. If it's more software-based or more, fintech, those risks are reduced. Generally speaking, for companies that are based in the European Union, you do need to take into account regulations that may be triggered in the European Union for you having a company elsewhere. I'm not sure about how it works on the Netherlands, but I know that, for example, in Germany, if you were to have a company in Prospera and you're the major shareholder and the legal representative of that company, there would still be tax obligations for you in Germany to pay for that company, for example. So there is an analysis that would need to be made locally in the Netherlands.
And something I would also like to add is that this is Honduran sovereignty. That this is something that was done by Hondurans in the Honduran Constitution, and Honduran politics is still active, so Hondurans are still deciding their own fate with sovereignty. And so, to me, there is a concern about parentalism from other nations still affecting Central and Southern America, so we're not up in arms about Guernsey or other special economic zones, Monaco, all that. So I'm personally really excited that Central and South America are doing all of this innovation and actually leading the charge. And then one thing I've heard, though, is that yes, this could be captured by, again, the traditional colonial nations. And so the question there is then, can Prospera own all Honduran lands? I know there's an election for land, but is that possible? How much land of Honduras could Prospera take over?
So, per the Constitution, only the coastal provinces of Honduras can be subject to a special economic zone. And it's worth remembering that Prospera, the zone, that's equivalent to a municipality, to a county. It's a public space. And within that municipality and that county, the owners of the land can be several, right? Like around half of the land that is inside of Prospera, the zone, is owned by Prospera, the company, which is a developer. But the other half is just, privately owned by whatever people that were already living on the island.
And they can secede, right?
Huh?
They can secede as well.
They can secede as well. Like say you have, an office building, right? And you don't want to pay taxes or be compliant with the local municipality. Hey, you say, no, I'd rather get my governance services from Prospera. So then you incorporate it in Prospera and say, you try it out, you don't like it 2 years from now, then you can bring it back out to the local municipality.
Maybe I want to add to that. I think his comparison with the Netherlands is also pointing to a very legit and very more important comparison, and this is that Netherlands has very high standards that are, let's say, GDPR, yeah, it's my specialization, but every builder from Netherlands or from European Union knows the GDPR. It's not easy to deal with, but if you keep it, then it also protects you from other companies not or using your data or just sharing something. And whenever you have a already established landscape, a highly industrialized zone like the whole European Union, these very high standards of course make sense, and they come with also tons of protection for the end user or for the citizen there. But this is not true for all industries. These limitations are very much oppressive to key industries that we need worldwide, at least somehow to happen, an outlet, so to say. Biomedical research is the best example. And there are other examples like this to be found. Maybe we need independent nodes for AI very soon because conglomerates like the European Union or like the Russian Federation or China or also the US have very strict surveillance standards. Maybe the surveillance protects you sometimes, but overall it's maybe not so bad if we have 1 or 2 places in the world where you can run a server or an Ethereum node without that top-down so-called protection from a nation state. But these are trade-offs, and these are exactly the right questions to ask if you want to be an entrepreneur in Prospera. Does this make sense for my use case? Do I live in an area where the value that I can create, and it's not just fleeing from taxes, because that would not need Prospera. There is like 100 zones over the world to do that. But does it make sense for me, the polycentric approach, to bring the value and the products also on the internet to the people that I want to reach? And I think with that framing, the question could be very well answered by Christian, but without the very precise use case and comparison framing, it's really very vague to answer. Does this make sense?
This was a great answer.
Thank you. Generally speaking, it's just more flexible, friendlier, more affordable. Right. So time. Thank you, everybody.